All right. Morning, everybody. Appreciate everybody's patience. We were waiting on a quorum, and we may still have. I know we're going to have a couple of members absent, or one for sure I know is absent. A couple others might come in a little bit late. We've only got one bill on the agenda, so we had a little bit of latitude here. Ms. Secretary, would you please call the roll?
Senator Berg, Senator Carroll,
Present in the room.
Senator Kerr, Senator Neal,
Present in my office.
Senator Schickel, Senator Schroeder, President Stivers, Senator Turner, Senator West, Senator Wheeler,
Present in the room.
Chairman Westerfield.
Here. Seeing that we have a quorum and we are authorized to do business, we're going to jump right in. We have with us Representative Samara Heverin and House Bill 310, and quite the phalanx here of experts and guests, and then Representative Nemes. With that, Representative, we're here on House Bill 310, which does have some modifications that were made over in the House. And I do want to point members' direct your attentions to the committee substitute, which was distributed this morning with very slight changes that I know Senator McGarvey, Senator McGarvey will get into. Because they are so slight, I know it's late on getting a sub, but the changes were that slight, I didn't think it would be a concern to go ahead and call the sub. So the sub is here for us to consider this morning. Representative, you have the floor.
Thank you. I'm Samara Heverin. I represent the 18th District, and I will let my guests introduce themselves.
Yes, my name is Jeremy Loxton. I'm Grayson County Attorney.
Jason Nemes, State Representative for East Louisville and South Oldham.
Julie Rocky Adams, Senate District 36.
Morgan McGarvey, Senate District 19.
Is everybody's mics on for when it's your turn? Make sure it's on. Okay.
All right, we'll do it.
There are three specific areas of this legislation that I would like to point out. First off, it requires the notice of the parole board hearings scheduled requirement to the Commonwealth attorneys from any prisoner convicted of a Class A, B, or C felony to any prisoner convicted for a Class A, B, C, or D felony that is defined as a sex crime under KRS Chapter 17.5. Currently, there's only opt-in notification that one can sign up for. This issue was brought to me by a constituent and one of my local county's attorneys in the 18th District. My constituent shared that she was not made aware of the parole board's meeting and found out her daughter's sexual abuser had been released from prison through a secondary notice. The second piece to this legislation is that it codifies that a conviction of attempted sexual assault qualifies as a conviction sufficient to allow a victim to obtain an IPO. Previously, the perpetrator had to actually complete the assault before the victim could obtain an IPO, and I was proud to work with the Kentucky Attorney General's office on this. For the last piece of this legislation, I would like to give the opportunity for Senator Julie Rocky Adams, Senator Morgan McGarvey, and Representative Jason Nemes the opportunity to speak. Unfortunately, Representative Cantrell could not be here this morning because she's teaching a law school class at University of Louisville. I will be honest and say that this is probably one of the most special pieces of legislation that I've got to work on because it shows how having conversations with your colleagues on both sides of the aisle truly do matter. Late one night when we were here, I was talking to Representative Cantrell, and the article from WDRB popped up that there was a loophole on a case in Louisville. And I was like, Mackenzie, what can we do? So we turned to Jason Nemes, which doesn't happen very often, and we started talking to him. And Representative Cantrell reached out to Senator McGarvey, and we were talking to Senator Julie Rocky Adams. And so truly, this is just a piece with rural and urban legislators working together to make a big difference in Kentucky on both sides of the aisle. So I greatly appreciate that. And I will turn this over to Senator McGarvey, who has a committee substitute as well.
Before Morgan goes, I also want to call out Senator Danny Carroll, who on the floor immediately was like, it came to Senator McGarvey and myself and said, how can I help?
And in caucus.
Yes. So thank you.
And no, thank you to Senator Rocky Adams, to Representative Heverin, to Representative Nemes, Representative Cantrell, Senator Carroll. And there have been a whole host of people that have helped on this, not to mention the prosecutors, the defense attorneys, the judges, the mental health professionals who've worked on this bill for going on 2 years now. This is a problem that we've known about for a while, and we've worked on it for a while. It has taken the Kane Madden situation in Louisville recently, I think, to really get the legislature's attention. But now that we have it, we want to give you a product which has not been thought up overnight, been worked on by a lot of people for a long time. First, I'll address the sub. The sub really doesn't make a big substantive change. What it does is on page 10 of the sub, it clarifies that this applies to a narrow group of people. And what the bill does, and I'll explain what the sub does with that, is a lot of people refer to this as a loophole. It's not really a loophole so much as it is a crack in the system that people are falling through. And that is, if you are deemed incompetent to stand trial and you are not likely to respond to treatment, then we let you go. And it doesn't matter the offense. Sometimes it could be a misdemeanor. I understand that a little bit. But sometimes you get into really serious offenses. And so what the sub does is clarify that this only applies to people with violent crimes or sexual crimes that they've been accused of committing. And if those people are deemed incompetent to stand trial and they're not likely to respond to treatment, then it immediately goes to another proceeding. We've tried to mirror so much of the language here in 202A and 202B that I know you guys are familiar with. Now we're creating 202C. And what you do is the first thing we have to do is we have to respect everybody's rights. And this came to us actually from the public defenders, where we're going to have an evidentiary hearing. This is not a determination of guilt or innocence. In fact, anything in this evidentiary hearing cannot be used in a criminal or civil action at a later point. But what we heard is there were instances in which people were accused of doing things. They were incompetent to stand trial. I think incompetent, really and truly unable to stand trial. But it could be proven there's no way they could have committed this crime. We were given an example of someone who had been stabbed, someone who was incompetent to stand trial, had been accused of the crime, but it could be proven they were physically incapable of inflicting these wounds. They just were not able to do it. So that's what this evidentiary hearing is for. It determines by a preponderance of the evidence whether there is sufficient reason to believe someone could be found guilty of a crime. Again, anything that comes up in this evidentiary hearing before a judge is not able to be used in a later proceeding. We have it in front of a judge, in front of a jury, and there have been some questions about this. Why do we have it in front of a judge, in front of a jury? Because judges are the ones who handle evidentiary hearings now. This is not a determination of guilt or innocence. If that is a stumbling block for people, I'm happy to talk with others about a floor amendment in that regard. But we just thought because of what it is that it's best to have an evidentiary hearing in front of a judge. It is not a finding of fact. This is not guilt or innocence for a jury. But again, willing to talk about that if that would want to be a floor amendment or as a stumbling block to getting out of here today. So you have that hearing. We guarantee that the respondent, not the defendant, the respondent is represented by counsel. Doesn't matter if they're indigent, they are eligible to have a lawyer for them and appointed to them. In addition to that, because of the sensitive nature of this proceeding, we have gone and made the step of having a guardian ad litem. I know that's something that Senator Rocky Adams advocated for and many of the people in the mental health community advocated for. The guardian ad litem is not in lieu of an attorney. It is in addition to an attorney. In fact, those two are there sometimes for separate reasons. The guardian ad litem may make investigatory findings, may look into it, but is there to protect the well-being of the respondent who's been accused of doing these things. If through the evidentiary hearing, by a preponderance of the evidence, it is decided that the individual might have done this crime or could have committed this crime, then you go into what we call the 202C proceeding. And this mirrors the 202A and 202B proceedings of determining whether someone can be held. We go through the same four-part test to be determined by a jury if the respondent so chooses. The respondent or the prosecutor can choose to have a jury just as they do in a 202A or 202B proceeding right now. And they must determine that four-part test that we're familiar with. And that is, hold on, you have to be assessed by a mental health professional. You've got to find reason. You've got to find you have to find that the respondent presents a danger to themselves or others as a result of their mental condition, that the respondent needs care, training, or treatment in order to mitigate or prevent substantial physical harm to themselves or to others, and the respondent has demonstrated a history of criminal behavior that is in danger to cause injury to others or has a substantial history of involuntary hospitalizations under 202A and 202B prior to the commission of this charged crime, and not or, and that a less restrictive alternative mode of treatment would endanger the safety of the respondent or others. So these safeguards are still built in there. After that, if it's found that they must remain in some type of custody, they are not going to a general population prison. They've not been convicted of a crime. They are incompetent to stand trial, but we have determined through this multi-stage process that their best interests and the best interests of the community are served by still having them continue to get treatment. At any point, the respondent can request a review of their circumstances if they can show that their circumstances have changed. This is in addition to the mandatory state review that we mandate at various points throughout. And you have a first one, I think it's within 120 to 180 days. Then you have one a year out. Then you have one 2 years out. And you have a mandatory evaluation even 5 years out still if someone is still in custody. At any point during that, in addition to those, the respondent and their attorney, they are guaranteed the right to counsel throughout this process, can say, our circumstances have changed. Maybe it's that they're going to respond to treatment. Maybe it's that they're competent to stand trial. Maybe the evidence has come forward that there's nothing it couldn't be them. It has to be someone else. So we've tried to safeguard this. This has been tricky. This is a crack that people fall through. And we want to be respectful of everyone's rights, but that includes the community. And when you look at what's happening in Louisville right now with an individual named Kane Madden, you'll understand why this is important.
Can I take that, Senator, as a motion on the sub? Is there a second on the sub? Second from Senator Carroll. Motion originally there from Senator Wheeler. All those in favor, are there any questions on the sub, the changes there on page 10? Seeing none, all those in favor of adopting the sub, please vote by saying aye. Aye. Those opposed? The sub is before us. Got a motion from Senator Wheeler, a second from the chair. Any further remarks from anybody on the panel about the underlying bill or the changes made to it, or any questions? Certainly. We've got some time, so feel free.
Yeah, I appreciate that. I appreciate the committee. I won't keep you guys here long now that you made a motion. My grandfather always said, don't sell past the close. But one of the things I think is important to understand how this really does impact a community. We have an individual in Louisville named Kane Madden, and he has been a revolving door through the judicial system. Every time he is held to be incompetent to stand trial and not likely to benefit from long-term treatment, meaning they're not sure he can get better. Because of that, the judges are forced to let him out. That's the only tool they have at their disposal. Within 24 hours of his last release, he is accused of beating an 8-year-old girl over the head with a shovel and raping her. He is up again for trial and has just been ruled incompetent to stand trial and unlikely to benefit from treatment. This bill would close the crack. It would get people the help they need and keep communities safe. I appreciate your all's consideration of it.
Anybody else?
Just want to thank Senator McGarvey for being the only one who spoke who didn't take a shot at me. Other than that,
Meeting's not done yet.
They called motion on the bill.
Chairman Westerfield, if it's okay, I would like for Mr. Loxton to speak,
Of course.
just because he drove from Litchfield this morning.
Of course.
Thank you. Jeremy Loxton, Grayson County Attorney. I've been a career prosecutor. I'm going on my 12th year of law practice. I sit as the director on the board of the Kentucky County Attorney Association. This is, the underlying bill is just there's already a foundation there. There's already a block in that foundation. We just need a better block for that. And D-sex crime victims absolutely should be included in that. And I think it's pretty straightforward and plain language that assists in that. Thank you.
Thank you. I appreciate it. I appreciate the work you do. And we're always glad to have somebody from the dead center of my commute from home to Frankfort. The closest Mr. Gaddy's to me. I'm grateful for Litchfield and the people there. Any other questions? Yeah, Senator West and then Senator Schroeder.
Thank you, Mr. Chairman. I think, Senator Carroll, were you first? Okay. My question's quick. I think this is fairly obvious. I'm I'm a real estate attorney. I'm not a criminal attorney. I know enough to be dangerous. So, as far as the bond, the ability to bond out, in some of these cases, if it's criminal and you're going through normal process, you can bond out. But I'm assuming on page 10 with the changes where you do an involuntary committal, that that opportunity goes away. Is that how that would work?
I'm not a lawyer, so I'm going to let either Senator McGarvey or Representative Demas speak on that.
Take a stab at it, guys.
Sure, I mean, go ahead.
So it's a matter of timing more than anything, right? Because they have to make the determination that he's incompetent to stand trial. And the bond question, a lot of the times, is made in the middle of the morning right after they've been arrested. So it is possible that someone would be able to bond out and then later be held incompetent to stand trial and then committed for the safety of the public. I would say that in many situations, though, when this population, and this is an overgeneralization to be fair, but in many situations when this population, someone in this population commits a crime that qualifies here, they have a litany they have a history of crime, and that would be picked up by our pretrial officers and be used by the judge to make the determination on setting their bond. So it is possible that someone could bond out quickly and then not be covered by the protections here, but I think that's the best we can do.
But as a quick follow-up, though, so once you flip over into the involuntary committal, I would assume you would have to lose that ability to bond, correct?
The bond goes away
Yeah,
at that point.
that's
I
right.
would say it depends a little bit on the situation. In that instance, the bond goes away because what you're determining is whether they're competent to stand trial. If you are incompetent to stand trial, and that's ultimately the reason you're released, then there is no bond because you can't stand trial for that offense. Where the bond could come into play is, let's say that someone under 202A, right now you have 360 days, I think it is, that you can be in custody without responding to treatment. Let's say that you get to 420 days. You're going to respond to treatment, or you're found competent to stand trial at this point because of the treatment you've received. Then the criminal proceedings come back into play in the bond issue. But as the incompetency, it would not come into play.
And I'll remind folks that if you miss that in the bill, there is a mechanism for a review, a recurring review, and it gets further and further apart, but they're still ongoing, I think, forever. As long as you're in that institutional commitment, the judge is going to have an occasion to go back and look at your commitment and the circumstances surrounding your commitment. So there's a safety valve there.
Mr.
Senator
Chairman,
Carroll,
if I could add real quickly, it's
Yeah.
pertinent to this. In Section 8, it does require a quick hearing, an expeditious hearing. I think it has to be no longer than 20 days. That's right. And that's on page 16. So that resolves some of the libertarian issues that I know that we all share.
Senator Carroll, did you have something before calling Senator Schroeder?
I do, Mr. Chairman. I also like to note that I received my first senior discount at Mr. Gaddy's in Litchfield, and I'll never go there again.
We do appreciate your business to our local economy, though, Senator Carroll.
On page 9 of the bill, under subsection 7, strangulation, help me understand the reasoning behind adding the criminal attempt conspiracy, because normally if there's something of that nature, it's basically just to assault someone, not specifically strangle someone. Help me understand why that's needed.
That is from the Attorney General's office, and I am not a lawyer, so I'm going to put it in layman's terms. We just wanted to make sure that in order for the person to get an IPO, that they didn't actually have to be strangled, or they didn't have to have the criminal attempt. They could get it if there was going to be an instance where that was going to where they felt that was going to happen, rather than the strangulation or criminal intent actually happening. So it was just they just wanted to codify that. And I'm not a lawyer, so if that doesn't make sense, I will give that to Representative Demas.
Senator,
That's just a very specific type
Right.
of assault, so it's kind of unusual.
I don't know if we did it last year or 2 years ago, Senator, but we trumped up the penalty for strangulation in particular. So it may have been 2 years ago. Thank you, Senator. And so it was. This is in keeping with that determination by the General Assembly.
Okay. All right. Thank you, Mr. Chairman.
Senator Schroeder.
Thank you, Mr. Chair. I have a comment and a question. Senator McGarvey, I apologize. You and I weren't able to connect before this meeting. I know state and local went over, and then I had health screening that some of us have to take today. First, for the comment, I had a circuit judge reach out to me, suggested that qualified mental health professional be changed to physician, psychiatrist, or psychologist. Not sure what all falls under there right now, so if we could just maybe consider that. I don't know if we have time, but maybe come back if we have to.
What I can give you, either in committee or later, I can give you the rationale for that. Bottom line, one of them does have to be a physician, which is the language of 202A now.
Okay.
So it has to be two qualified mental health professionals. One of them has to be a physician. The other mental health professionals are outlined in the bill, and all must have a specific, not only expertise and education, but also practical experience and training in dealing with individuals that have these types of problems.
Okay, thank you. So then to my question, and this is the big issue for me as I know what has happened, know how serious of an issue this is, but then also look at our Kentucky Constitution and Section 7 and Section 11, and where I sit and I'm struggling. And I know, like, to try to get us, it's a tough way to work around everything to deal with a limited situation. So, and I greatly appreciate all of you working on such an important matter. Help me understand, though, when it comes to the right to have a jury trial in a criminal proceeding, and what we're doing, and I guess some of the rationale behind it.
So, in my mind, and again, I'm willing to work with people on this if it causes a lot of heartburn. In my mind, the constitutionality is in the involuntary commitment proceeding, and there a jury trial can't happen. The evidentiary hearing is just to make sure there should even be an involuntary commitment proceeding. It's an additional safeguard. And again, it was the public defenders who actually brought that idea to us, which is, do you have affirmative defenses? And it references affirmative defenses in the statute. Do you have affirmative defenses right now that you can prove by a preponderance of the evidence that there's no way you could have even done this? I mean, let's say that you were receiving inpatient treatment at the time this offense was committed. Then there's no way you could have done it. I gave you the example of the physicality. It was physically impossible. You were in a different place at a different time. You have cell phone records showing you were at somebody's birthday party. Those are the affirmative defenses you could provide. Not to mention just other type of evidence about the crime, whether there is DNA left behind, whether there's things you can present. So the evidentiary hearing really is just a ruling on those evidentiary matters. I personally am okay with a jury trial on those evidentiary matters, but we don't have juries. I mean, I'm okay with it. I see Senator West gave me the look. I'm okay with it because I generally favor jury trials, but these are questions of law that typically go before a judge. And so we're trying to leave those questions of law before the judge and then have the commitment proceeding in front of a jury.
Okay, so I heard the standard for the affirmative defenses, but I guess the judge's standard, we're changing the judge's standard too, as far as?
To a preponderance of the evidence.
Okay.
And again, only to see if there can be an involuntary commitment proceeding. So the involuntary commitment proceeding is the same as it is under 202A and 202B. But we are putting the evidentiary hearing, and I've told several people this, if it makes you feel better, we'll take it out. What it is it's an additional safeguard to people who've been accused of doing this. And so that's why if I seem pretty calm about the whole thing, that's why. I mean, this is a safeguard that's in there because we are trying truly to protect everyone's rights and understand that this is a sensitive situation. And you've all heard me say this about the First Amendment and other things. The rights that most need protecting are the ones that sometimes make us uncomfortable. And so we're trying to build this in to safeguard those rights. But the evidentiary hearing is just that. Is there enough evidence that we are going to have an involuntary commitment proceeding under what is now going to be 202C for this narrow range of individuals who fall into this crack? Incompetent to stand trial, not likely to benefit from treatment, have committed a serious violent or sexual offense.
Mr. Chairman, if I could real quickly, because I'm glad Senator Schroeder brought this up. This bill has given me, this whole issue since I've been elected has given me a lot of heartburn. I remember when we discussed Tim's Law, we can't commit somebody for this. And I remember his mother saying to me, My son died with all his constitutional rights intact. And that meant a lot to me. So while on one side I completely agree, and I think we're probably very similar, maybe everybody on the committee, that this is the soft spot or the most difficult area of government. We're going to involuntarily commit somebody who hasn't been convicted of a crime. We are showing, and I think Senator McGarvey and Senator Adams have done a really good job of threading the needle here, because we're very limited in the offenses that we're covering here. Then we're throwing on all kinds of protections. I've had 202 cases in my practice, and what I see a lot of people who slow down, because we know the judiciary was really fast. Everybody slows down. We got all these protections in there, guardians and attorneys for the person to be committed, slows down, takes it very seriously. And so I think we've threaded the needle here on one of the areas that's the most difficult, at least for me, in government.
Seeing no other questions, we've got a motion on the second and a second on the bill as amended by the sub. Mr. Secretary, please call the roll.
Senator Berg, Senator Carroll,
Vote aye and explain my vote.
Yes, sir.
Simply want to say thank you all for all the effort. Very disturbing. I think public safety is a basic tenet of government, and this was one particular area that I think we have been failing in, and it's very much appreciated that we're filling in that hole, and public safety will benefit from this. So thank you.
Senator Kerr, Senator Neal,
Aye.
Senator Schickel, Senator Schroeder.
Mr. Chair, explain my vote.
Yes.
Thanks. I believe this bill is going to have the votes necessary today to get out of committee. I'm going to pass. I'm going to follow up with you, Senator McGarvey. I know you guys have worked so hard on this. I certainly don't want to slow it down. That's not my intention. I just want to get comfortable with the constitutional concerns. And there was something else I was going to say, but it escapes me right now. So
You were going to change your vote.
I think we're
to
all
yes?
tired. No, I know what I was going to say. Thank you. I was going to say, Senator McGarvey, I believe you said on the Senate floor a while back that, we should be addressing this issue, and I wish we had taken it up sooner. So I wouldn't be passing today and could be comfortable. But I hope to get there for the floor, so thank you.
President Stivers, Senator Turner.
Yes, sir.
I'm going to vote aye, and I wasn't here when you all worked on this. I'm new, but I've practiced law since '78, and I know what it was back then, and I see this big step for the first time, because that poor person that was charged incompetent just stays in jail till the time expired. The grand jury went out, and they were free again, and then the grand jury re-indict them, but there was no process for them to have any right to present evidence of showing that they didn't commit this crime or any of that. So this step is really something that's been needed for a long time, and thank you for all the work, and I'm voting aye.
Senator West,
Aye.
Senator Wheeler,
Mr. Chairman, I vote aye. Explain my vote.
Yes, sir.
I also want to commend these fine legislators for this good piece of work. As stated by Senator Carroll, I think that government's first obligation is to protect the public, and this bill goes a long way towards doing that, especially with this horribly tragic situation that we're all aware of in Louisville. People like that, if they can't be helped, they really do need to be in a facility where they're protected as well as the public at large is protected. And I think that the very carefully scalped legislation that you all have come up with accomplishes that. So I just want to say thank you for bringing this bill.
Chairman Westerfield.
I vote aye. Bill passes with favorable expression. 6 votes in favor, 1 pass, no nay votes. Representatives, and senators, thank you all. Mr. Logsdon, I appreciate it. Thank you for making the trip, and I appreciate your all's time. I'm looking forward to seeing it make passage on the Senate floor. So I appreciate your all's effort to do something, and again to address a very real situation that's happening in Jefferson County. But that's obviously not the only place where these cases pop up. And I've prosecuted a case that actually wouldn't be captured by this. It's at the very low end of the offense spectrum, so it wouldn't even be in the population of people, the very narrow population of people that this affects. But this is for the people that are impacted by it, the crack or that gap, as you mentioned, Senator, is enormous and has lasted for decades and decades. And so I think you have threaded the needle, Representative. I appreciate those remarks, and I think you've managed to do something here that, frankly, threads a very challenging needle to thread, and does so in a way that protects the interests and the constitutional rights of those involved in just about every way I can think of doing, and still having plenty of safeguards. So job well done, and I appreciate it. And seeing no further business before this committee, I'll entertain a motion one more time to adjourn what I think will be our last meeting. We are adjourned. Thank you.